Thank you. To introduce myself, I'm Chuck Van Horn. I'm a partner at the law firm of Berman, Fink, Van Horn in Atlanta, Georgia. Thank you for joining us this morning. I've been practicing for just over 24 years, primarily in the commercial litigation arena, representing a host of business owners, and I do a lot of financial institution work. I am very fortunate for my practice in business litigation to actually try at least one long jury trial every year, which in this day and age is fairly rare. So I actually get to do cross-examinations, which, like Jim said, is probably one of the funnest things, very challenging, but one of the funnest parts about litigating. So let's kind of dive in. The first section or portion we're going to kind of cover today is some of the basics, the rules of the road on how to kind of set up yourself for cross-examination, called the rules, research, and preparing for a good cross-examination. Most of you will have some flashbacks to some trial classes in law school, the Irving Younger's 10 Commandments of Cross-Examination. And after having done this now for a few decades, there are no truer kind of maxims than some of the things Professor Younger introduced, even in that long, kind of hokey black and white video we all watched quite long, some time ago. Those 10 Commandments are kind of tried and true, including some of the ones we've always kind of had burned into our heads about ask only leading questions, ask no question to which you don't know the answer. And then some of the other ones are a little harder. Listen to the answers that you get, which may seem obvious, but we'll talk a little bit about that today. Don't quarrel with the witness, avoid repeating direct exam, and try to come up with ways to frame questions that do not permit the witness to start explaining their answers. And then the hardest one in many respects is don't ask the one question too many. So we'll kind of talk some of those rules from Irving Younger you're going to see mixed in through my presentation and Jim's throughout the day, and it's worthwhile to kind of go back and find any of the papers from Professor Younger because it really is a great place to start. Let's take one step back though, a little bit of kind of, especially for those of you who have not had an opportunity to try a lot of cases, this may seem a little unorthodox, but primarily cross-examination is a function during the trial that will happen right after the direct examination from that witness or that party's lawyer. One exception to that, and I'll talk about this a little bit from a preparing standpoint when we kind of talk strategy a little later today. One exception, however, is you can call someone for purposes of cross-examination in your case in chief. And it is a quite effective tool if done correctly, but don't do it just because you get to do it. And one quick note about that, and then we'll kind of keep moving on. So if that was not very clear, because it sounds like in my head it wasn't very clear, that is, let's say you're the plaintiff in a case. You may want to call the defendant representative to the stand during your case in chief, and they're called solely for purposes of cross-examination. You get to put the witness in the witness box and go through a cross-examination to pull out certain pieces of evidence that may be crucial for the jury to hear as they're hearing the story for the first time. It will be without the filter of the defendant's version of things. You'll be able to kind of hone in on some crucial pieces. There's a lot of good strategic reasons to do that, including keeping an eye on directed verdict issues to make sure you can get certain pieces of evidence in the record before you rest your case in chief as the plaintiff. And then there's some other strategic advantages, including what really is the most obvious. You get to cross-examine the defendant twice. And in the right case, that can be a pretty valuable tool. Under the federal rules of evidence, they kind of articulate what the true purpose of cross-examination is. A party has the right to a thorough and sifting cross-examination. And under the federal rules, there is some permissible kind of breach outside the scope of direct examination if necessary. Be fully prepared for the witness's lawyer to challenge any questions you ask during cross that seem to start going outside the scope of the direct examination. But just know under the federal rules there is the permissible kind of widening the scope of the exam, and it's not necessarily limited solely to the direct examination. Under both the federal rules, and I practice a good bit in the Georgia state court systems, leading questions obviously are permitted on cross, although in direct examination, as we all know, they're typically frowned upon, particularly when they go to more substantive issues. You don't have to do a cross, and there's nothing in the rules that require it. You may elect not to examine it or cross-examine a witness, and you really need to kind of think through whether you're going to jump in and do a cross-examination. And we'll talk a little bit about this later. Also, I strongly encourage you, don't do a cross solely for the sake of hearing your own voice. As tempting as it may be to do a cross-examination, you really need to kind of think through why you're doing it, which goes back to other seminars that I'm sure you've all attended about coming up with a trial plan and mapping out what each witness will do to help your case and what each witness can do to hurt your case, and really be strategic about when you do cross-examination, and if you do, then to what scope. So if we're going to do a cross-examination, we need to figure out where we're going to come at a challenge to the witness. One of the more effective means to undercut the import of a witness's testimony from their direct examination is to identify evidence that makes that witness unreliable or not credible. Because one of the charges to the jury will be to assess the legitimacy of any of the witness testimony heard during the trial. And as part of that, then, and this is where your closing will come in, you will be able to identify for the jury that a particular witness, yes, of course, Madam Juror, they said the following information, but you have to recall that that same witness couldn't tell you all these other facts, and therefore that witness's description of the events is considered unreliable. So we have to go find some places that we can kind of poke holes in the witness and make that witness look to be substantially less credible than potentially the witnesses that we want to convince the jury about our view of things. So the starting point for all of that are the discovery materials. And I think there was a seminar Jim and I actually spoke about previously, and maybe you were participants in it. We talked at great length about coming up with a good discovery plan and why that's so valuable, and to really overcome the tendency to just crank out rote discovery and really work hard on identifying what you truly need in a case and why. And this is one of the places where those extra efforts will bear fruit, is identifying areas where a witness's credibility or unreliability can be exploited. So you got to master all of your discovery materials. A lot of times you'll end up going outside the typical discovery, and you'll be using a lot of non-party discovery, again, to try and kind of come up with a good wealth of information about the witness or about the circumstances of things that you can use to point out a witness's lack of credibility. Outside of discovery, and you have to remember, you have witnesses who are both lay and expert. So on a lay witness, a lot of times you're going to be poking through their social media feeds, posts that they may have made on Facebook and other places where, for instance, they may characterize an event in a certain way, and then in a courtroom they're going to characterize it in a different way. That gets us into ESI, that gets you into a host of other things that are very important for rounding out a witness's perspective on things. For example, if you're talking about a termination event at a business, is it quite possible that a witness may have texted a friend of theirs, "Can you believe such and such just happened?" And making sure that you're conscious of that throughout the discovery process and that you find that information is very helpful for when the witness later starts describing the termination event in a much different light. So you have the investigation of witnesses online, and I want to talk about that in just a moment. And to back up for 1 second, we also have to remember that some of the cross-examination techniques will be utilized against expert witnesses, and the preparation for that is slightly different. A lot of that is going to be into deep dives on the expert's prior work, prior opinions they've given, prior cases that they have testified in, whether they tend to always testify for a plaintiff, for a defendant. Things like that all will be part of your hoarding of information about the witness, and out of that you will start identifying patterns where you may be able to exploit a witness's prior conduct in a way that sheds them to be unreliable or not credible in the jury's eyes. I mentioned a minute ago kind of rounding out your research by examining social media, something that when Jim and I both started practicing, we'd never even heard of. It didn't exist, but it is really a very important piece of digging around in cases to make sure that you're not missing what could be a very crucial nugget, and cross-examination is one place where that can really bear some fruit. But you have to be very mindful. Under the model rules of professional conduct, lawyers are compelled to stay abreast of technology, be competent and diligent in their representation. And that includes, of course, being savvy about how ESI works, savvy about different social media platforms and what those platforms represent, what kind of data may be there. But you also have to be mindful on limitations that lawyers have in terms of their interface with witnesses, interface with people who are represented or potentially represented, or kind of mischaracterizing their role when they are playing around in the social media platform.
Let me make a quick point
Absolutely.
on that, Chuck. And the flip side of that is so I'm going to go investigate a witness online. I'm going to look at Facebook. I'm going to look at their LinkedIn. I'm going to look at Instagram. I'm going to look at all the kinds of things I can look at. And maybe I'm just getting a picture of what they're like in a social setting, and it's just more information that will be helpful when I get to them in court. But of course, the flip side I want to mention is you need to have a discussion with your own client who are going to be witnesses and talk to them about what they've posted and the things that they're doing, because obviously cases have long durations and there'll be a history that's put on these. And again, that doesn't mean that you can't have any fun in life and put things on Facebook. You just better be mindful that as much as you're looking at somebody else's material, they're looking at yours, and you need to be cautious in that regard in terms of what you got out there.
Absolutely. So as you are diving into the social media platform, we're getting into an area of kind of an evolution. That is, you're going to see continued disputes in this arena, and I would advise you to stay abreast of any recent decisions as the discovery battles take their way into social media. And I will spotlight a few issues that are kind of in the evolution phase as we speak. One is, can you friend somebody? And I think the conventional wisdom seems to be that you cannot reach out and friend someone through Facebook who may be a witness in a case as a means to gather additional information from them, because otherwise a lot of their posted information would be private. Once you're friended, you're kind of behind the proverbial curtain and can gather additional information. I think that also will hold true if you were to utilize a private investigator or a third-party service for that investigator to similarly friend or connect with someone, which would permit them to gain a deeper access on the social media profiles. It's considered frowned upon, and I have every expectation that there will be more and more kind of discovery battles and therefore court opinions as we try and round out just how some of the model rules of professional conduct apply in these very specific situations, particularly in an evolving social media world. Let's talk about the flip side as we're issue spotting for you. Jim was identifying that you also have an obligation to alert your clients to, be very conscious that what they say on social media, highly likely they have to expect that it not only will be read, but it will be read and used against them in appropriate settings, and that they need to exercise due caution in what they post. Under the Model Rules of Professional Conduct 3.4, there's a maxim about lawyers not unlawfully obstructing another party's access to information, and can't alter or destroy or conceal a document. There is some thought then that rule in its literal application could limit a lawyer from telling their client to go and turn off all of the kind of public settings, if you will, on their social media profiles, thereby kind of locking a lot of that information behind closed doors. I'm not certain I actually see it that way, because you're not destroying or concealing anything. You're just making it more difficult to find. But you can see where that area, the model rules obviously were not crafted specifically with this instance in mind. And that's going to be another area where you really need to kind of keep abreast of court opinions about exactly how a change, for instance, in privacy settings, once a case gets cranked up, you call your clients in and say, you guys need to shut this down, if that can trigger any issues. Pennsylvania Bar Association has spoken some about this, and regarding attorneys' use of social media, and I think other bar associations will similarly kind of weigh in as this reaches the forefront. I will tell you from a war story standpoint, one of the funner cross-examinations I did for a host of reasons unrelated to social media. I took over a case for a lawyer, no discovery had been done, so I tried a 5-day jury trial with no depositions. So the common source of information for cross-examination, outline prep, was missing. But one of the things I did have was open access to Facebook posts by family members of the primary party in the case. And I used the photographs from those Facebook posts to great effect. And even talking to the jury after the trial, in the adage of a picture tells 1,000 words, some of the posts from the family of conduct they were engaging in around the time of this business transaction that was being hotly contested was hugely helpful. It had a certain kind of wink nudge to it as well. The story in the case was that a defendant was claiming essentially a lack of capacity or understanding in entering into some sophisticated business agreements. And when they were later sued under those agreements, they claimed lack of capacity for, in short order. And I had a series of Facebook posts when the family had gone skydiving in Las Vegas, including a picture of the predictable sign that says, this is hazardous activity, you have to sign a waiver to do this, and all the big bold letters you would expect there to be outside a skydiving facility. And the kids had posted this and then posted a picture of their family members all dressed in the parachute gear about to get on this airplane. And I used that to say, did it occur to them that mama was totally incapacitated and was incapable of even understanding that she was getting on an airplane and that she had signed her life away and a host of other things. And I think it had a great impact on the credibility, going back to the theme here, of the witness claiming that they didn't understand these business documents that they had signed just a few weeks before. So that's kind of a fun place to get information about witnesses, is looking kind of outside the normal discovery tools and the online facilities. A more mundane, but substantially probably tighter to your case way to get fodder for cross-examination is the use of depositions. And this is worth spending some time on. Using depositions to obtain information or concessions from a witness are crucial to crafting an effective cross-examination. I want to talk for a minute about, in particularly, some of the line of work that I'm involved in. A lot of the cases have a host of summary judgment issues, so that's a common kind of stepping stone in a case before you would ever have an opportunity to try your case. taking a deposition, there's a lot that goes on. For those of you who have taken a lot of depositions, it's really not as easy as it may ultimately seem when you're watching someone else do it. But remember that the summary judgment use of a deposition and the trial use of a deposition are substantially different. And you need to be mindful of that fact when you are taking the deposition. And in the written materials that you have, I've given a couple examples that I've taken from actual depositions in cases I've been involved in. Names were changed to protect the innocent or not so innocent. But those examples, as kind of hokey as they may seem, I think get across the idea. So I'm asking a witness a question in a deposition, and as part of a kind of bumpy, jumbled, or just kind of cut into many pieces answer, the witness concedes or gives me the fact that I need. For summary judgment purposes, my job is done in the back and forth Q&A on that issue. I don't need to belabor the point because I can cite to the court appropriately that some fact has been established without equivocation, and I can cite to that passage in the deposition. But if you were to look at any of the passages that I referenced, to use any of those in cross-examination would be hopeless, is the only word that comes to mind. That is, if the answer from the witness is part of a longer answer, or if it's part of a jumbled kind of fits and starts answer, it's still evidence, it's still admissible for summary judgment purposes, but for cross-examination purposes, impeachment in mind being one of the primary, that Q&A is virtually useless. I mean, imagine the witness's testimony in a trial differs from this jumbled passage, and you were to walk through with the witness, didn't I ask you this question? It was in an office, it was under oath, and all of the impeachment kind of foundation things, and we'll talk about that later today, that you would want to do to set up your impeachment opportunity. But then you can imagine you'll say, see where and you quote the question, and then see how you answered, and then maybe, and then I said this, and then you said this, and then I said this. You have lost your aha moment. So just remember that. There may be times that you will need to circle back in a deposition and walk through a couple of these facts again to make sure that your question is succinct, because we've all asked some pretty crummy questions, and that the answer is succinct so that if you're ever in an opportunity to impeach the witness, you have a very concise, cut and dry question and a concise, cut and dry answer. Anything else is going to be very difficult to use for impeachment purposes. So while we're on the deposition phase, remember that although a lot of the deposition fodder is done for motion practice and for a variety of other reasons, including just sheer discovery of information and learning about transactions and events and who knew what. Keep an eye on the ultimate use of those things at trial. I highlight in the materials and here in the outline the role of speaking objections. I think hopefully we have hit the apex of speaking objections really being problematic. And at least where I practice, we're starting to see that being scaled back some. A speaking objection would be where the defending lawyer kind of launches into a long colloquy criticizing either the questions you're asking or the lines of questions or the way you're saying things. And it is done very transparently as a way to either coach the witness or to dissuade you from going down a certain line. We are seeing more and more, the federal judges were the leaders of this where I practice, issuing kind of case management discovery orders that are very specific about a lawyer's role in a deposition and utilizing the power of the court to decree up front that speaking objections are prohibited in their cases before them, and a lot of our state court judges are coming up with deposition rules up front, and I'm noticing, at least anecdotally, I feel like it's having some impact on this. Where that becomes important for cross-examination purposes a year down the road, you've really, one, lost some of your fodder, but also when you're impeaching a witness, you have this huge speaking objection sitting in the middle of your Q&A, And it's very difficult for you to navigate through that in front of a jury without really kind of falling all over yourself. But I think the bigger issue is just in your discovery, fact-finding efforts, you may have a lawyer kind of thwarting your ability to really drill down and pin a witness down on a story before the lawyer interferes and tries to color the witness's testimony all under the guise of some objection, as opposed to keeping the objections kind of short and sweet. One tangent to the use of deposition transcripts and cross-examination. Federal Rule 30b-6 is most commonly known in, for purposes of identifying a corporate representative who is capable of testifying, be the spokesperson, if you will, on a series of pre-identified topics. There is a means in the rule, I think it's B5, but it's a subsection of the 30b rules here, that allow a party to introduce the 30b-6 testimony without putting the witness on the stand. You get to just lay out the testimony in the middle of your trial. You don't need to impeach anyone. You don't need to set them up. Instead, the transcript is just read to the jury during the course of the trial as if the witness were sitting in the courtroom. In case you didn't know about that small, largely kind of untapped use of 30b-6, because I think we tend to like to have live witnesses in the courtroom, frankly. But it can be an enormously helpful strategic tool. And let me point out for you a couple reasons why, just to kind of throw this out there for you to think about. Particularly in an instance where a party has really not done probably the depth of preparation that would be appropriate for a 30b-6. Someone is nominated, that witness starts testifying, and you can get a series of concessions out of that witness about things that they either don't know, that they don't understand, that they haven't done yet, that they have not conducted this investigation, or they have not reviewed this set of materials, yet they're speaking on behalf of the ABC Corporation on this topic, which I think it's fair to describe that they are the person who is best equipped to answer questions about this topic. Slightly different than saying you're the most knowledgeable, because that's frankly not what 30b-6 requires. But if you can get them to concede, because I think this is an accurate description of how the rule works, that they are best equipped for the company to speak on this topic, you get all these concessions. You don't need that person getting on the stand having testified on direct and testified probably better, they'll be better prepared, and then you have to run in and cross-examine them. Forget it. Just launch. Just read the transcript pieces up front, and it can be an enormously effective tool. My reading of the rules, frankly, do not require you to identify the passages to your opposing counsel before you use this. Probably better practice to go ahead and do that, particularly if you're going through a sophisticated trial and you're going to have a judge who's really going to frown on you introducing this if it starts slowing down the trial, if the opposing lawyer starts objecting. But the rules certainly allow you to utilize some good testimony out of a 30b-6. So it's almost, you cross-examine them in the deposition and you think, I really can't do much better than that. So go ahead and use it maybe in your case in chief and just throw the company's representative out there by way of deposition, and you will get to sit on your laurels from having done really well in a deposition months or even years before your trial. So we've talked some about gathering some information both through discovery, depositions, and other items, as well as kind of going outside the traditional discovery phase, social media and other investigatory tools, all as the source for information you're going to use for cross-examination. So let's kind of transition into best practices for preparing for cross. These are fairly obvious here. Master the facts. You have to have thorough discovery, and you have, as the lawyer, have to have a command on that discovery, which in this day and age is ever more a burden, and it's just a greater obstacle because the vastness of discovery never ceases to amaze me. Then, of course, having depositions of all these witnesses, if you're fortunate enough to have the opportunity to have deposed the witnesses ahead of time. And then last, make sure you have a comfort and a good working knowledge of all the rules of evidence, because they will be crucial to where the weaknesses may be in the direct examination that you can exploit through cross. So mastering the facts becomes pretty obvious, and goes all the way back again to some other presentations Jim and I have done together about coming up with strategy for trial, and you have to have a plan and a roadmap and all of those things. This is, again, another area where it will really end up kind of rearing its head, for the better or worse, is to recognize what you expect to get out of this particular witness when you go in. So prepare your notes and your outlines and your exhibits accordingly for this witness. The way I tend to do my outlines is I will write out all of my cross-examination questions, which for me personally is a huge deviation from the way I do other things. I don't write out all my deposition questions. I tend to not write out very verbose outlines when I'm arguing motions and hearings and those sorts of things. But cross-examination for me is totally different. Now, it is not scripted, but I have written them all out, and it's, for me, I do it as a check and balance to make sure that the examination has a sequence to it, and that there is a build-up to the 1 or 2 or 3 crescendo moments that you want throughout your cross-examination. Where I use deposition transcripts, and I would encourage you to do the same, is every place that I'm asking a question in my outline that I can support the Q&A from a deposition, I will have that cite, page and line, very specifically referenced in my question. 99 times out of 100, it becomes a non-event, because you're either going over things that are fairly fundamental or that it's difficult to imagine the witness will deviate from. But in the you never know category, having it right there, outline sitting in front of me at the rostrum or something I can carry in my hand as I'm walking around the courtroom, I know that that question has already been answered by the witness and exactly where I got it. And that goes further. If it comes from a specific document, if it comes from a pleading, or some other source, just have that source right there, directly attributable to that Q and that A, so that in the event you do need to impeach, you're not going back to your table, whispering to the other lawyer you're trying the case with, fumbling through papers or everything else, because you've lost the jury, you've lost the judge, and the impact of all of that is just kind of lost. You want everything to just flow as if you know everything that's about to happen, as opposed to it being very kind of jumbled and scattered throughout. So knowing where the Q and the A come from all the way through any outline, to me, is kind of the be-all and end-all for my crosses. Inside of that, kind of categorize some of your evidence. Kind of know what you're looking to get at for each kind of fact. So that is, are you looking to introduce some evidence with this witness? Then you need to make sure that you have that categorized appropriately. And you have set out in your outline when that witness, when you get to a point where you thought you've presented the foundation appropriate for getting a piece of evidence in. That can oftentimes occur when you're calling a witness for cross-examination in your case in chief, when you know I need to get the following 3 or 10 documents into evidence, and I can really only do it through, let's say, a company representative rather than your own client. So you need to make sure that you have things kind of identified ahead of time. Also, along the lines of categorizing evidence, you have to know everything that's already been introduced in the case. There's nothing worse than grabbing an exhibit, running up to a witness and thinking that you're really going to be able to sucker punch them and get your aha moment that we all kind of wait for, only to learn that the witness has not only never seen this document, but neither has anyone else in the courtroom. It's not been introduced, it's not been admitted, and the judge starts to castigate you in front of the jury for waving something around that's not previously been marked, identified, and admitted in the case. And then you kind of go back to your table with your tail between your legs, so you lost your aha moment, and you kind of look silly, which is kind of the double whammy. So I was talking about structuring an outline. I literally will write out every question, and what I have learned over time in terms of structuring the outline is my crosses tend to be, by outline, exceptionally long, especially compared to other things where I don't heavily rely on kind of writing everything out. And I think it's largely a function of, I have learned the hard way of trying to kind of go for the home run, or the kind of grand slam or knockout punch, whatever phrase you want to use, too early. I strongly believe in kind of writing out each question to build up to the crescendo moment, and in that then having one question begets the next question begets the next question, and moving in small pieces to make sure that I am appropriately leading up to whatever point I'm trying to make. Whether it be, the Matlock moment that we're really waiting for, or even if it's a smaller piece of evidence, but it ultimately ends up being fairly crucial in the presentation of your story. So the cross-examination, I strongly encourage you to structure it appropriately, to work through issues in a certain form so that the jury's able to follow you. I contrast that with a lot of people, and sometimes I fall in this category, the deposition kind of strategy tends to be to kind of just wander around. Because if a witness gets too comfortable and they know where you're going, they can see things coming, they can start almost thinking, or they think they're thinking a little bit ahead of you, and it may not be nearly as effective. So a lot of times you'll see lawyers jump around in a deposition and come back to topics and then move to other topics. I strongly discourage you from doing that in cross-examination, particularly when you're trying to set the stage for a certain conclusion. Use a lot of very small questions to get up to it. Don't just jump in and say, isn't it true, such and such, expecting them to say, yeah, you're right, our case stinks, you're correct, we should sit down, I don't even know why we're here. It's not going to happen. So you just have to really work through it, and the structure is very important. With that, please be flexible, please be willing to deviate. Going back to one of the Irving Younger rules about listen to the answer. So take the answer from the witness. So now we're no longer using our outline, but we've mastered where we're going with it because we've kind of orchestrated it correctly. Take the answer, flip that into the next question. Okay, you just said such and such, and then you move to the next little tidbit. Take that answer, and then you move to the next little tidbit, and the witness is really, they're stuck, right? Because it's their words that are being used. And again, you're not going to jump to the aha moment right away. You're just going to keep kind of leading them through. But having a structure is super important because it will, frankly, I believe, allow you to be more flexible once you've kind of scripted out where you want to go and how you think you're going to get there. I think you'll be able to set yourself up to utilizing the witness's words. And then I've kind of mentioned this a little bit already, the pre-mark and number exhibits. In the event that this particular cross-examination witness will be the source for the identification and ultimately the admissibility of certain evidence, have it all ready. Have it there so that your examination just flows along and cruises along. For me, I prefer to have really no dead time in a cross-examination. I want it to move quickly and just very efficiently. They don't tend to always be very long, but I want to just be able to kind of click through. I don't feel as restrained when I'm doing a direct. If I get to a certain point on direct exam, I never felt like as long as you don't wear out your welcome, a jury's going to really hang you for taking a moment, 5 seconds, 10 seconds, which may seem like an eternity, looking at your outline, and then just say, okay, I think we've covered that. Now let's move to this. in cross-examination, I never feel comfortable having that kind of dead time. I want things to just move along. It keeps the witness engaged, it keeps the jury engaged, and the more engaged they are, I think the more effective anytime you're trying to make a point will come across. The idea of don't overshoot comes up even in the evidentiary issues. If you don't think that, if you're not confident that this witness will be able to identify and will be able to lay the foundation to get something into evidence, in the middle of the trial is not the time to try or to explore. That's where your discovery and your investigation ahead of time should come in. The worst would be you pick up an exhibit, race up to the witness to start to get them to identify it, with your plan being it will be admitted through this witness, and then they're like, I don't know anything about that. That's not me. I didn't do that. That's not my job. That's someone else's role. And then you look like you're kind of scrambling, but also your plan of making sure that evidence was timely admitted in a certain pattern kind of gets a wrench thrown into your script. I want to talk for a minute, though, about this is the other side of things. That is, your clients are going to testify in the case, and that means they're exposed to cross-examination. So a lot of the things that I've just talked about will also come up in readying your own client or your own witnesses for cross-examination. Everyone who's listening or participating in this seminar kind of knows how trials work, has been in a courtroom, has seen a trial, tried a lot of cases. Your clients and your witnesses, their only exposure to this, depending on their age, is like LA Law or some other TV show, and that's it. Maybe My Cousin Minnie or A Few Good Men, and that's about the long and short of cross-examination. So we need to be very conscious of making sure the clients are fully aware of how the logistics work for purposes of cross-examination, including just the simple things. You know, when I finish my examination, I'm going to return to the table, I'm going to sit down, and then the judge is going to look at the other lawyer and invite that lawyer to stand up and cross-examine you. You don't get to take a break usually. You certainly don't get to confer with me. You're going to be sitting in the same spot, but remember, the hostility or the challenge of the questions will be much different. You and I were working on an engaging back and forth, trying to be very warm and telling a story, and now they're going to try and trip you up and get you to kind of fall over yourself. So having the client understand or the witness understand what's coming can ease a lot of what is very legitimate anxiety. I have kind of written here in the outline, rehearse but don't memorize. The rehearse, though, is just crucial. This is substantially different than working through interrogatory answers, substantially different than even having their deposition taken. The deposition likely from the adverse lawyer will have certain components to cross-examination, but I suspect that most of us experience witnesses, their own clients, being deposed in a manner that's normally not super challenging and uber aggressive, because that tends not to be a good, effective tool in depositions in most circumstances. But cross-examination is much different. So you have to rehearse. You have to go through and say, you know, didn't this happen? Isn't this true? Isn't it accurate that such and such? And get the clients to start understanding how to answer those questions, where they don't look evasive, they don't look unsure of themselves, or that they start kind of violating some of the other rules of the road for cross-examination, including, like, don't fight facts you can't fight, right? If they're asked a question, sometimes you concede and say, yes, that's accurate, and you move on, because there's this just built-in natural resistance to conceding anything, and as we all know, that can really just start kind of spiraling out of control, going back to one of the initial tenets at the beginning of the presentation about establishing or poking holes in reliability and credibility. Your client does not concede a fundamental fact that every other witness has said yes to, and they're doing it solely because, oh my God, I'm in cross-examination, and because the other lawyer is asking me this and saying, isn't that true? It must not be true. They just want me to say it's true, so I'm going to say no, and then I'm going to have to fight for my territory. And you can see that quickly spiraling out of control, where they've really kind of lost everyone, giving them a lot of credit for things, and their credibility is shot. And anything else that's done in the case is kind of diluted by virtue of the fact that they came across as either unlikable or unbelievable, or worse, both. So practice cross-examinations. Some crosses will be very hard-hitting and aggressive and volume raising and challenging and everything else. Expose them to that, because you just can't predict what the opposing lawyer will believe to be very effective under those circumstances. And then one of the other things in the outline here is something that really cannot be underscored. This is not easy, and if for whatever reason you find that you struggle with the following concept, there may be others that you work with who are better at it, but the ability to explain complex legal issues in simple layman's terms is frankly an art form. And having your clients and your witnesses understand the legal issues at play in non-legal terms is very important. It's important for a host of reasons, but where it comes up in cross-examination is the opposing lawyer will be asking questions using non-legal words you would expect, in a way that the jury can follow along, and trying to hit at crucial issues in the case, whether it be, statute of limitations, waiver. It was a sunny day versus a cloudy day, and you couldn't, the sun may have been blocking your eyes. That is a bias or credibility, whatever the issues are, but make sure your witnesses know what's at play. So that will help them understand the means by which they can tell their best story, but also be able to interpret why questions are being asked a certain way. So for example, if you know that waiver is a concept that's at issue in the case, and you can explain to them that, not speaking up or not voicing objection to certain things over a long period of time may make it more difficult to raise an objection later. Not a great example, but in the landlord-tenant context, if the landlord accepts late rent payments for a really long time and establishes a new norm, it's very difficult to complain later when the tenant is late and to seek defaults and remedies. It's hard to imagine that coming up in a trial context, but because it's so simple, it's a good example to use. Have your landlord-client know that, right? So then if they start getting asked, well, you took the January rent 8 days late, right? Yes. You took the February rent late 8 days, yes. But if they know why that's an issue, you have worked up ahead of time the appropriate response. And you will have practiced that in your anticipating cross-exam and the practicing a cross-exam. If they know what legal issues are at play, it will can have a huge impact on the way they respond to questions from witnesses. And one of the last things here is look the part. That seems simple, but they don't need to be setting any fashion records, but have your witnesses look like that they're engaged, that they take this seriously. So knowing where to walk, where to sit, how to address people, and that they have actually reviewed materials ahead of time, as opposed to just their serial I don't knows, which I think Jim will cover this afternoon, because that's an art form in and of itself. But just have your folks just generally be ready. Have them know what documents are germane to the case and what they're likely going to see, how to respond when shown a document. Don't be flippant, don't be cavalier, don't be disrespectful. And we probably have all had these things happen where even our own clients, opposing parties shows them a letter or an email or whatever it may be, And they're like, what, you want me to look at this? Oh, you want me to read this? I didn't even bring my glasses. Like it's the lawyer's fault that the witness is totally ill-prepared. And frankly, they come across as flippant and disrespectful because the jury came there every day, the jury brought their reading glasses, and caution, just have your witnesses be likable, and that includes, they can stand their ground in cross-examination. That's probably the last takeaway for preparing your own clients. They don't have to give, isn't it true? No, I think you misunderstood, that's not accurate. It's a very nice way of saying it as opposed to no. And it sets the stage for things to be explained again on redirect, to clarify things later, but also going to the unreliability and the credibility issues. If the witness can start identifying politely, you must have misunderstood. They're being very polite, very respectful of everyone, but also kind of telegraphing right to the opposing lawyer, Madam Lawyer or Mr. Lawyer, you're not prepared. That question, instead of being like, are you kidding me? That's a silly question. Much better for them to say, you may have misunderstood, that's not accurate. And then they're setting the stage to start explaining. So in the do's and don'ts on reading your own client and your own witnesses, and some of these I'm going to kind of review quickly because this is this for me is like the tightrope of all tightropes. It's just, you lost control, your client's up there getting cross-examined. Word to the wise, tell your clients or your witnesses not to tell the opposing lawyer that their questions are silly. That happened to me more than once. I don't even know why you're questioning me on this. Also not very helpful. And the list goes on and on. You get the point. That's where you kind of want to just slip down below the table and be like, oh my God, apparently my prep sessions weren't all that effective. So, practice and practice again. So walk through the cross-examination with your clients, practice them. It'll make you better. It will make you start anticipating kind of what's coming for them, and just make sure that they are fully prepared. Now, I didn't go over this yet because some of this seems so basic, but give your witnesses a copy of their deposition transcripts, of course. But when you're going through and practicing cross with them, you need to be able to start identifying areas of the deposition where they are exposed, as opposed to just saying, hey, read this, let's meet on Wednesday. Witnesses and clients are busy people too, and even when they read it, do they know why they're reading it? Do they know what they're really supposed to be focused on? It's just kind of really work through that. I can't emphasize enough, the last thing you need is for your own client to start torpedoing a 1.5 or 2 years worth of work because they come across as unlikable and undesirable for some reason. And if it's attributable to a lack of preparation, that's just really very discouraging for all the work done to date. For going back through, just kind of to review quickly before we wrap up this section, we talked about procedure and rules. We talked about finding evidence of unreliability and lack of credibility. On that note, you do have, of course, some of the obvious cross-examination tactics that I didn't cover specifically. That is the ability to impeach a witness based on criminal prosecution and those sorts of things. But those are, of course, things that go to unreliability. And I think later we'll talk some more about cross-examining experts. So I didn't go into great depth about means by which you can poke holes in an expert's testimony, but there are a bunch of them that in and of itself could take almost an entire seminar. Investigating witnesses online, kind of the do's and don'ts. There are areas you absolutely need to be conversant in, engaging in social media. I think the conventional wisdom today is not to friend a witness on Facebook or something in order to get additional information out of them. The direct messaging platforms in a variety of the social media fora is also kind of a stay away. But other investigation of witnesses online is total gain. And that includes if these witnesses have testified in other trials, right? So you're talking about your 30B6 witnesses, corporate representatives, in the business context, and Jim may have seen this, but I've certainly seen it. You have people who are much more litigious than others. So if they've been involved in other cases, go try and track down a deposition or two and just see what they say, see how they behave. And that may be also an area where you can kind of start getting stuff. Don't forget, in the reliability and credibility arena, the interrogatories that everyone starts to just kind of put on the proverbial shelf, a few months into the case, those are all sworn statements under oath. In a lot of the cases I'm involved in involve some kind of injunctive relief, and a lot of those pleadings are verified. So you have additional sworn statements that may be a good source above and beyond just mere deposition testimony, to get statements that you can get them to either agree or disagree to and undercut their credibility. And then how you start marshaling all of that information to prepare for a cross-examination. Come up with some goals, and it should only be a few. You're not going to score, you're not going to hit 10 home runs in one cross-examination. It's just not going to happen. So don't set your sights there, but know that you need to either get certain information in, get concessions on these specific topics, and then you can kind of start working towards the build-up questions that will get you there, crafting that into a very workable outline that makes it kind of foolproof for you to be able to identify impeachment sources when you need them. And we'll discuss impeachment in greater detail later. And then how you can take that witness outline and use it for helping your own clients and say, okay, you and I practice direct a lot. We're trying to make you smooth. We're trying to make you comfortable and warm. Now know that we're going to have a change of heart, and you're going to put a different hat on, and you're going to ready your client for the same very tactics we discussed. That is, be very conversant in the deposition, be conversant in the pleadings or interrogatories that may be used against them, and all the other sources. So that's kind of the rules of the road and how to prepare for cross-examination.